Testing, testing, 1, 2, 3. Testing, testing, 1, 2, 3. Again, going through the first rundown of the E.J. Lee Law Legally DIY Trademark course. The first installment of the course is searching through the USPTO records and how to conduct that search on your own. So we're going to go through this briefly, and then we will do the official run. So I go to this website quite a bit, so this link is already saved onto the Google homepage, so I'm going to click on there. As you can see, if you're using the workbook, I am on the homepage of the USPTO website. And as you can see under here, you have a number of different things. You have patents, trademarks, IP policy, learning and resources tools. I'm going to make this simple as possible, and this is where we're going to go, searching trademarks. So we're also on the next page, which you should also see in your workbook, and you'll see a couple of different things that they would like you to use or to consider, should I say, regarding searching these marks. And it says before you apply, you should search the USPTO trademark database to see if any trademark has already been registered or applied for that is, 1, similar to your mark, 2, used on related products or for related services, and live. Live just simply means one of two things. It means that the trademark is presently going through the trademark process, so that does not necessarily mean that it's been registered or that the mark has received both a serial number and a official registration number, which means that technically you would not be able to register for that particular trademark if it's in the same protection class that you would be claiming for whatever product or service that you offer. So now we're going to click here on search trademarks and actually go through the records. So again, if you're using the workbook, you have 3 options here. The other 2 are way more complicated and requires a little bit more instruction. So we're just going to focus on the easiest one to do as a basic trademark search, and that is a basic word mark search. We're going to go there. So as you can see here, we're going to be focusing on these particular terms here. Dead means that for whatever reason the trademark is no longer in use, or it was denied for whatever reason, but those marks are no longer alive, which is where you see you have live and dead or live. For the purposes of this particular trademark search and tutorial, we're just going to focus on live and dead trademarks. So if you're using the workbook, I am going to click on, or I'm going to search for my business model, which is Be Creatively Legal, to see if that mark is presently in use. So it takes us to this page which says no trademark electronic. Make sure I know what this is. Sometimes I have to check myself. Trademark electronic search system records were found to match the criteria of your query. Click on the back button in your browser to return to the previous page. Or the previous screen. So this is great. This is telling me that no one is presently using this trademark or this service mark or this phrase, this quote. Now, this does not necessarily mean that I will receive registration for my mark. It just means that as of right now, this mark has not been registered with the USPTO. But there could be a number of reasons why no one else chose to register this particular phrase. They may have received legal advice that told them that this wasn't a good trademark or whatever the reason is. But don't just assume that when you come to this page that means that you are going to be granted trademark registration with the USPTO, because that's not what that means. But this is a good thing if this is what you come to based upon your own search of the proposed mark that you want for your particular company. So now we're going to go back as it instructed to the back page. So now we're going to search a mark that I have been doing a lot of discussions on during my Facebook Live posts and whatnot regarding trademarks. So one of those is called Trap Karaoke. So that is the one we're going to search right now. And again, if you're going through the workbook, it should be showing you that on the next page. So if you look here, we have two records for Trap Karaoke. We have this one, which is called Re-Rock's Trap House Karaoke, and then we have this one, which is Trap Karaoke. Now, if you're in again, using the workbook, I did not take screenshots of this first one, but I do go into a little bit of this particular one, Trap Karaoke, as to why that particular mark was put on the supplemental register versus the principal register. So I'm going to click on this one just for the purposes of this tutorial to talk a little bit about why this one received principal registration versus supplemental. So again, this particular company is registered under the International Class of 41, which covers a multitude of different areas. But namely, one of the areas that it covers is entertainment. But here, this particular company has claimed goods and services of arranging, organizing, conducting, and hosting birthday parties, arranging, organizing, conducting, and hosting social entertainment events, disc jockey services, entertainment in the nature of live performances by karaoke performers, and a number of different things. You can read through it if you want to. This particular registered also used an attorney, which is good. The only thing I don't care for is that it is registered in the company or the owner's personal name, and I never recommend for any person doing business to have their trademarks registered in their personal name. To me, they should be registered in the name of your business. It just keeps separation between you and the trademark. If for whatever reason you are sued, you would prefer to be sued under your business and business assets versus your personal. But that is a matter of preference. You can obviously you can put it in your individual name, as you see here on the screen. So also, I want to point out here that it is on the principal register, which means that no one will be able to use this name, Re-Rock Trap House Karaoke. It is sufficient enough to distinguish this competitor from other competitors also offering karaoke services with a focus on trap music. So that's the reason why I wanted to click on this, so you can see that there's a difference between being on the principal register versus the supplemental register. And if you want more information on the principal versus the supplemental register, I did a blog post about that on my blog on the website. So you can go there and find that and read through it for more information on the difference. So now we're going to go back to that second record we found, which is here, the Trap Karaoke. So again, we're looking through the records and we see we have a basic word mark. He again also applied for the International Class of 41, which again covers a multitude of entertainment areas. And he claimed entertainment services in the nature of live musical performances. He also filed his trademark under what is called 1A. And what that basically means is that he is presently using this mark in commerce, and it is being offered for sale to the general public. So that is the filing basis that people file when they have established use of their trademark. Because contrary to, most people believe, just because you come up with a trademark phrase or a slogan that might serve as a trademark does not give you ownership of it until you have associated that proposed mark with a product or a service. And then you can claim protection in that area. And so that's when you claim the current filing basis, or this filing basis here, of 1A. If you decide you want to put yourself in line with your trademark, you would do the filing basis of 1B, which is intent to use. And so when you file that particular application, you are given 1 year from the date to establish use of that trademark. Secondly, they don't really go through the records to determine whether or not your mark is actually competing with someone else. It basically just puts you in line to establish use at that point. At least that's my understanding of it. I could be wrong, but again, always seek independent legal advice just to be sure of how the 1B filing would work. So again, we see that this mark is on the supplemental register. And so we're going to click on this here, which stands for Trademark Status and Document Retrieval. So we're going to click here on that little button. So here we see a little bit more about this record. And now we're going to click on Documents. So the thing that we're going to focus on this page, as you can see as you're walking through the workbook, this person received an office action. Now, generally speaking, we don't want to receive an office action because they're basically the trademark examining attorney has found a reason to either deny this application or there are a number of changes that they are requesting. So we're going to click on here to see why this particular trademark received this office action. So you're going to scroll down. And we see here that while the USPTO examining attorney did not find any conflicting marks, the mark was refused because it is descriptive of the service provided, or called Section 2E1, Descriptiveness Refusal. And basically it is saying that registration is refused because the applied for mark merely describes a feature or characteristic of the applicant's services. And so I've said before, when you are creating a trademark, it cannot be descriptive of the product or service that you provide because you cannot stop competitors from using those terms if it is the terms that you would use to describe the service provided. Keep in mind that when we go into business, that we don't own the idea of a business. We only own or are entitled to rights where it is an original expression of the idea. So I like to give the example of a restaurant. Think of the restaurant, or in particular, a fast food restaurant, as the big idea. Think of McDonald's, Burger King, Wendy's, Taco Bell as the original expression of those ideas. And so those individual names, each one of those would receive trademark protection because those are the names that they have chosen for their companies, and they're unique enough to where they stick out and they don't prevent other competitors from using the terms necessary to describe the services that they provide or the products that they provide. So in this case, Trap Karaoke is literally what it is that this particular owner provides. He provides karaoke music selections that are of a trap music niche or service for you to provide. So that is literally what it is that he provides. And so if there's another competitor that also wants to provide trap karaoke, it's reasonable that he would not be able to stop them from saying trap karaoke if that is literally what it is that they provide. The words are too descriptive of what it is that he provides. So the mark was pretty much refused. So what ended up happening is we're going to go to the next document and we're going to click on his response to the office action. So when you respond to an office action, you are given 6 months from the date of receiving that office action to either present evidence as to why you feel the registration should be allowed. And sometimes you have to cite case law. You have to do research to, again, prove to the USPTO why that mark should be registered. But in this case, the user decided to ask if his mark could be put on the supplemental register, and it was granted. So the reason it appears that this was allowed is because obviously the examining attorney believes that possibly at some point trademark karaoke can serve as a trademark for this particular user. I would argue that if other companies decide to provide trap karaoke, that this user will still not have a strong enough argument to block them from doing so. And so I'm not sure if this trademark will eventually be able to go onto the principal register. But they usually give you about 5 years from the date. So he probably spent about $225 to file this initial application. And so even though he's on the supplemental register, he will have to refile again to get placed on the principal register. When he plans to do that, who knows? But again, I will be watching this application for a while. So I'm going back here. And as we can see, he was issued a certificate on the supplemental register. Now, hopefully you have been following along enough on my blog, on my Facebook Lives to understand why it's so important to pick a mark that isn't at all descriptive of the service that you provide. You want it to be the kind of mark that makes you tilt your head and think, now, why did she pick that or why did he pick that? But with clever marketing, significant marketing, you can convince clients or consumers to associate whatever trademark you've picked with your company. It just takes some clever and creative marketing to do that, but you can make it happen. Think of some of your strongest trademarks, such as Apple or Starbucks. When you hear those names, you automatically think of the products that they're associated with, which is Apple being associated with phones and Starbucks being associated with coffee. Now, I'm sure when you first heard those trademarks, you will kind of possibly wonder, well, why did they pick those trademarks? But after years and years of marketing, you hear those names and they have become synonymous with those particular products. And so those marks are so strong and work so well that other competitors will not be able to legitimately argue behind them and say that they should be able to use those marks to describe their products, because Apple is not at all descriptive of a phone and Starbucks is not at all descriptive of coffee. So if you're looking through the workbook, I have written a section where I say review or reevaluate your trademark that you have chosen, whether you're already in business or whether you're going through the process of planning your business. Ask yourself, is your mark descriptive or too descriptive of what it is that you provide? If it is, then you might want to reevaluate that mark, because you might not be able to stop competitors from using those terms if that is in fact the product or the service that you provide. And you want to think of something that is whimsical, that is completely different from what it is that you do, to where you can stop competitors, because you work very hard for your intellectual property. And so you want to make sure that you're able to distinguish yourself in the marketplace as much as possible. So I hope that you have found this tutorial to be helpful and that you're able to finally come back for a consultation with EJ Lee Law, to where we'll go ahead and file your application. If you have purchased this tutorial, you can receive credit towards future legal services in filing your application. And I look forward to working with you soon. As always, be creatively legal.